day at the Supreme Court. It's kind of a great time to have this discussion.
Absolutely.
Yeah.
Okay, ladies, we can get started whenever you're ready.
Okay, great. Thank you, Erin. Good afternoon. My name is Tona Boyd, and I'm Chief Counsel to Senator Cory Booker. On behalf of Senator Booker, I want to thank all of you for joining us today, and I want to thank the Lawyers Committee for Civil Rights for partnering with us on this important briefing on the Supreme Court term. This summer, as millions of people have taken to the streets to demand that America reckons with systemic and institutionalized racism in the face of relentless police violence and brutality against Black and Brown communities, the Supreme Court, an institution that has historically been a battleground for racial justice, is wrapping up another term. Today, we'll hear about the court's civil rights docket from Kristen Clarke, the President and Executive Director of the Lawyers Committee for Civil Rights Under Law, which is one of the country's pivotal national civil rights organizations in the pursuit of equal justice for all. Under her leadership, the organization has been at the forefront of some of the nation's biggest racial justice problems today. The Lawyers Committee seeks to promote fair housing and community development, economic justice, voting rights, equal educational opportunity, criminal justice, judicial diversity, and more. We are very fortunate to have Ms. Clarke joining us today. Throughout her career, she has focused on work that seeks to strengthen our democracy by combating discrimination faced by African Americans and other marginalized communities. Clarke formerly served as the head of the Civil Rights Bureau for the New York State Attorney General's Office, where she led broad civil rights enforcement on matters including criminal justice issues, education and housing discrimination, fair lending, barriers to reentry, voting rights, immigrants' rights, gender inequality, disability rights, reproductive access, and LGBTQ issues. Under her leadership, the Bureau secured landmark agreements with banks to address unlawful redlining, employers to address barriers to reentry for people with criminal backgrounds, police departments on reforms to policies and practices, major retailers on racial profiling of consumers, and one of the country's largest school districts concerning issues related to the school-to-prison pipeline. Kristen received her bachelor's degree from Harvard University and her law degree from Columbia Law School. We'll start today with a presentation from Kristen and then reserve the final 15 to 20 minutes of the program for questions. Now I'd like to turn it over to Kristen Clarke.
Thank you so much, Tona, for that very kind and warm introduction, and many thanks for creating this space for us to reflect on what a monumental term that has just closed out at the U.S. Supreme Court, and many thanks for all of the great work carried out by your office and by Senator Booker. Very, very grateful for your leadership as well. And thanks to all of those who are joining. We know that the pandemic has upended the world, and it has been remarkable to see the Senate soldier forward under these circumstances. So grateful for all of you who have made time to participate in this discussion today. So some overarching observations about the term. This term has demonstrated once again the significance of the Supreme Court in American society. The justices took on incredibly important cases this term, dealing with issues such as LGBTQ discrimination, criminal justice, reproductive rights, immigration, presidential power, and much more. I'm going to hone in on a few select decisions of the term that most affect the work that we do in the civil rights and racial justice context. And I think that what we find is that this term was a mix of victories and defeats, which given the current makeup of the court is not surprising. Most of the victories were very close. We saw a lot of decisions that came down on 5-4 or 6-3 votes, and many decisions that turned on technical issues like stare decisis or a failure on the administration's part to comply with procedural requirements. And even in those cases, the conservative views of the swing justices are reflected in the opinions. Given the current composition of the court, victories will likely be difficult to sustain, and the decisions in those cases will likely be very narrow in scope, meaning that we're likely to see rulings that are not likely to have broad impact. We're going to have to fight hard to hold the line, let alone to make gains. A few observations about Justice Roberts. Justice Roberts, notably this term, voted to expand LGBTQ rights. He voted to protect dreamers. He struck down a Louisiana abortion law. He has very much become what someone would describe as the new center of the court, a powerful member of the court. As of last week, Roberts was in the majority about 98% of the time this term. It's a remarkable number that's up from a rate of about 88% in his first 14 years on the court. We know that there are rumors that a current justice may announce their retirement in the coming days. And I will just say that I think that this is a moment where many are starting to do work to prepare for a potential vacancy. Justice Kennedy announced his retirement at about the end of June and at the close of a term. And it's possible that in the next week or two that we may hear news of a retirement this term as we close out this term. I think that this is a really critical moment for everybody to be preparing for that possibility. And that work would include working to get pertinent information right now on potential nominees, whether that's through Freedom of Information Act requests or public record requests. I think that one lesson that we took away from the hearings surrounding Justice Kavanaugh is just how critical it is that there be transparency. And I recall that there was a great and protracted dispute about getting a hold of Justice Kavanaugh's records from his time in the White House. So doing work now to ensure that the public, that the American public will have as transparent a process as possible, I think is very, very key. I also think that it'll be important to scrutinize the views of any nominee on issues like civil rights and racial justice issues. This term makes clear that these issues come before the court with great frequency. We'll want to know issues like the nominee's views on racial discrimination, their views on issues like sexual harassment and diversity and more. So with that, with those opening remarks, let me turn to this past term. I want to kind of go back to the start of the term and focus on some of the criminal justice cases. And I'll start first with Ramos versus Louisiana. This was a case that involved the question of whether the Sixth Amendment requires a unanimous jury verdict. And whether that right to a unanimous jury verdict is incorporated to the Sixth Amendment by way of the 14th Amendment. In 1972, the Supreme Court ruled in a case, Apodaca versus Oregon, that a unanimous jury was not required in state court cases. In 2018, Louisiana voters passed a referendum requiring unanimous verdicts, leaving Oregon as the only state that did not require this. However, the Louisiana referendum did not apply retroactively, and Mr. Ramos was convicted of second-degree murder and sentenced to life in prison without parole in Louisiana. 10 of 12 jurors voted to convict him and sentence him to life in prison without parole. Here, Mr. Ramos argued that his conviction, by way of a non-unanimous jury verdict, violated his constitutional rights, and in a 6-3 decision by Justice Gorsuch, the court extended the Sixth Amendment's right to a trial by jury to require a unanimous verdict to convict a defendant of a serious offense in state courts. I think the takeaway here is that criminal justice has been an area of incremental progress under the Roberts Court, and this case is a good example of that by eliminating the last vestiges of allowing criminal convictions from non-unanimous juries and recognizing the discriminatory and, in fact, racist origin of these laws, particularly the law that was on the books in Louisiana and in Oregon. Next term, in the fall, the court will consider a related question, and that's whether this decision, Ramos, should have retroactive application. Another case, criminal justice case that went before the court this term is McKinney versus Arizona. This case involved whether the Arizona Supreme Court was required to apply current law when weighing mitigating and aggravating evidence to determine whether a death sentence is warranted, and whether the correction of error under a case, Eddings versus Oklahoma, required resentencing. We submitted an amicus brief in this case in support of the appellant, James McKinney, who was a death-eligible defendant. We focused on whether the resentencing needed to be decided by a jury instead of a judge. In this case, the resentencing decision was made by the judge. Current law requires resentencing to be decided by the jury, and the question before the court was whether the current standard needed to be applied retroactively. We submitted a brief discussing the non-exhaustive collection of considerable constitutional rulings in which defendants would be deprived if retroactivity did not apply to resentencing, deprived of their constitutional rights. And in a 5-4 decision by Justice Kavanaugh, the court held that when capital sentencing errors under Eddings versus Oklahoma are found on collateral review, the state appellate court may reweigh the aggravating and mitigating evidence, not a jury. The takeaway from this case and from these two cases is that where a judge instead of a jury imposed a death penalty sentence prior to the Ring decision, the judge erred in deciding what evidence should be considered as part of the resentencing. And the appellate court weighs aggravating and mitigating circumstances on review instead of having the case sent back for resentencing by a jury. So two important cases to be aware of. I'm going to move next to the Comcast case involving one of our nation's oldest civil rights statutes. And this was probably the most important race case heard by the court this term, Comcast versus National Association of African American Owned Media. This is an odd case that involved the question of whether plaintiffs are required to show but-for causation to prevail under our nation's oldest civil rights statute, 42 USC 1981. Meaning, do defendants have to show that the contested action at issue would not have been taken but for race? This is a longstanding civil rights law that was enacted as part of the Civil Rights Act of 1866 and sought to ensure that newly freed slaves would have the equal right to enter into contracts as whites. Congress was clear that it intended to broadly attack contractual race discrimination in any form when they put this law on the books. This law is a very important complement to other civil rights laws like Title VII. This is a law that helps to combat discrimination in the employment context, in the housing context, lending and retail context as well. The Supreme Court issued a decision in this case, essentially finding that plaintiffs have to show that race was the but-for cause for contested injury. Oddly, just a few weeks ago, Comcast and the litigant in this case reached a settlement, which is unfortunate. It means that this is an important case that probably did not have to go before the Supreme Court. But it now leaves us with a federal statute that arguably is significantly weakened. It may shut the courthouse door on some litigants who really need the benefit of discovery to establish the true motivation behind contested action. I think that it may be important for us to think about whether there are ways to strengthen this statute down the line. Just by way of example, we have Title VII, which puts in place important protections against discrimination on the basis of race in the employment context, but this law does not apply to independent contractors and gig economy workers. Those kinds of individuals could invoke the protections of 42 USC 1981. So we'll have to see how the court's ruling makes it more difficult for people to invoke the protections that had previously been afforded by this important statute. I'll turn next to the voting context. The pandemic has upended many aspects of our life, including our elections. This spring, in a case, Republican National Committee versus Democratic National Committee, we saw the Supreme Court step in to intervene in lower court decisions during the 2020 election cycle. This particular case arose out of Wisconsin and concerned the April 7th primary election, presidential primary election, and also involved a seat on the state's high court and other state and local races that were on the ballot. A district court judge issued a ruling extending Wisconsin's deadline for absentee ballots past the April 7th election date due to the pandemic, which had created a backlog in absentee ballot requests and frankly made it impossible for most voters to have enough time to receive the ballot and return it by election day. The RNC sought an emergency stay from the Supreme Court to stop the district court's injunction from going into effect. And the day before the election, in dramatic fashion, the governor of Wisconsin issued an executive order seeking to suspend in-person voting and endeavoring to move the election until June 9th. However, the state Supreme Court overturned that order in a 4-2 vote. On the heels of that, the Supreme Court issued a ruling issuing a stay on the federal district court's decision, and that essentially meant that any ballot not postmarked by April 7th would not be counted in the state's election. There was a dissent issued in that case by Justices Ginsburg, Breyer, Sotomayor, and Kagan, expressing great concern about the potential tens of thousands of Wisconsin citizens who likely would be disenfranchised and unable to return their ballots or drop them off in person on election day. I'll turn now to another case that the Supreme Court intervened in just several days ago out of Alabama. That case, People First for Alabama versus Merrill, involved a stay on an 11th Circuit Court decision that would have eased certain Alabama witness and photo ID requirements placed on elderly and disabled voters for an upcoming July primary. Alabama is a state that requires absentee voters to submit a copy of their photo ID and have 2 witnesses or 1 notary sign the absentee ballot envelope in order for that ballot to count. Incredibly burdensome requirements, particularly during a pandemic. The district court issued a preliminary injunction that essentially prohibited local election officials in 3 counties from enforcing those provisions against many voters. And that injunction had barred the Secretary of State also from halting curbside voting. The Supreme Court stepped in and issued a stay, meaning those restrictions are back in place. And so I think that what we're seeing is that this is a Supreme Court that will not be shy to intervene in these cases that are playing out during the midst of the pandemic that involve access to the ballot. We are likely to see a Supreme Court poised to stay lower court decisions throughout the 2020 election cycle. And this is an incredibly fraught area because there are literally cases playing out in courts all across our country that are seeking to address the restrictions and barriers that voters are up against. I think that one thing that it would be important for Congress to do at this moment is to look carefully at legislation that has been put forth in both houses that would provide funding to states to help institute the reforms needed to lift and address some of the barriers that voters face. We also think that it's very important to think about the need for funding for the U.S. Postal Service, an agency that's really critical to the success of vote by mail this season. Oversight of the U.S. Postal Service to ensure that their processes are transparent and to ensure that they're doing their job in the appropriate in terms of appropriately handling and timely delivering and returning ballots is also key. We're seeing that the USPS plays an outsized role this season. Issues like the date on an absentee ballot will prove critical in determining whether or not a ballot counts. One new development from yesterday, Florida voters with felony convictions have asked the Supreme Court to intervene in a voting rights dispute playing out in the state involving the question of whether or not people who have criminal histories must pay all court fees and costs before they can register to vote. There's an 11th Circuit order that has put a trial court ruling on hold in this case, and voters are seeking to lift that stay and provide some clarity as time on the clock dwindles away as people work to ensure that they're able to vote during the 2020 season. I'll move next to talking about Title VII and sex discrimination and the LGBTQ cases that came before the court this term. The Supreme Court decided 3 cases involving LGBTQ people, and the question of what protections they are afforded under Title VII of the Civil Rights Act is an issue that was squarely before the court. The Bostock versus Clayton County, Georgia case and Altitude Express versus Zarda case both involved whether Title VII covers people who are gay or lesbian. And the R.G. and G.R. Harris Funeral Homes case involved the question of whether Title VII covers people who are transgender. We submitted a brief in this case on behalf of a few dozen civil rights organizations. The issue here is one of statutory interpretation. Title VII bars discrimination because of sex. And the central question was whether taking an adverse employment action because someone is gay or transgender is discrimination because of their sex. Plaintiffs provided a simple argument in their favor. If an employer fired a male employee because he's dating a man, but does not fire a female employee because she is dating a man, the male employee is being fired because he is a man, and therefore he is being fired because of his sex. The Supreme Court issued a favorable 6-3 decision in this case. The decision was authored by Justice Gorsuch, who is a textualist, who held that an employer who fires an individual merely for being gay or transgender violates Title VII. And he wrote that, quote, sex plays a necessary and indisguisable role in the decision, exactly what Title VII forbids. I think this case shows that Justice Gorsuch is poised to stay true to his word about being first and foremost a textualist. He very much used the language of the text as the predominant means of interpreting the statute here. Firing an individual on the basis of LGBTQ status is indeed discriminating on the basis of sex. And I think at the same time, this case will likely lead to more lawsuits regarding other statutes where sex is a protected basis and somebody's rights were violated because of their LGBTQ status. I think the other issue to keep in mind here is that we will likely see more cases in which courts will have to decide whether freedom of religion and free speech rights allow businesses to treat LGBTQ people differently in this context. And indeed, there's a case coming up next term, Fulton versus City of Philadelphia, which involves this very question. What can we do? The Equality Act is a statute that passed the House of Representatives last year, and that may be one avenue of bringing wholesale reform to this area. Otherwise it's an area that will have to be resolved through multiple cases, statute by statute, playing out through the courts. There are a number of groups that supported passage of the Equality Act, which would provide kind of comprehensive wholesale reform to this area. I'll just note, though, that there are many civil rights organizations, including ours, that have concerns about opening up our bedrock civil rights statutes without having guardrails in place. We're very wary that when we do reopen bedrock civil rights statutes, we do so in ways that won't result in harm, mischief, or otherwise weaken these critically important laws. Let me mention a few cases that are somewhat related on religious freedom that just came down. Yesterday, the court issued a 7-2 decision in 2 sets of cases, Our Lady of Guadalupe School and Morrissey, Berry, and St. James School versus Beale. So these cases involved teachers at religious schools and whether they are covered by a so-called ministerial exception, which gives religious institutions the constitutional authority to discriminate against employees who are deemed faith leaders or ministers. The opinion here was delivered by Justice Alito and Sotomayor with Justice Ginsburg in dissent. And also just a few days ago, the Supreme Court issued another decision in this space, Espinoza versus Montana Department of Revenue, a 5-4 decision in which the court ruled that states can't bar religious schools from receiving the same public money that non-religious private schools received. The court ruled that barring religious schools from federal tax credit voucher programs would violate parents' religious freedom. Chief Roberts delivered the opinion of the court here. The ruling is definitely a win for someone like Secretary Betsy DeVos, who has proposed tax credit programs to help parents pay for private schools. And she's also been someone who's very much supported the idea of siphoning off funds to allow parents to send students to faith-based schools. And she, in fact, issued a statement lifting up the ruling of the court here. I'm going to turn now to DACA. This is probably the most highly watched case of the past term, a case that had implications for about 800,000 undocumented people who are overwhelmingly immigrants of color who would have been denied the opportunity for economic advancement and the opportunity to live here, but for a favorable ruling issued by the court in this case. There were 3 cases that the court heard in this space: DHS versus Regents of California, Trump versus NAACP, and McAlleen versus Vital. In each of these cases, the lower courts held that DHS's decision was reviewable and unlawful because it was arbitrary and capricious under the Administrative Procedure Act. The administration's primary defense was that the Obama administration's original decision to put DACA in place was unlawful. So their decision, the Trump administration's decision to rescind DACA, is unreviewable and lawful. The Supreme Court earlier had deadlocked 4-4 on the legality of DACA, and as a result, lower courts finding that DACA was legal were kept in place. Here, the Supreme Court issued a decisive 5-4 ruling that was authored by Chief Justice Roberts, and the court held that the Department of Homeland Security's decision to rescind DACA was arbitrary and capricious under the APA. In particular, the court found that the agency's decision to terminate DACA was reviewable because it was a program that conferred affirmative immigration relief, and thus the creation and rescission of that program provided a focused action for the courts to actually review. The court also found that the APA requires that a decision to rescind that program required a reasoned analysis, and here the government failed to meet that standard because the agency did not address whether there was legitimate reliance on DACA throughout the country, and instead the agency relied solely on the Attorney General's conclusion that the benefits were illegal, and the AG did not consider other options. Plurality joined Justice Roberts, Justice Ginsburg, Breyer, and Kagan. I will note that the court decided not to take up the equal protection claims that were also put forth in this case. That would have looked at the question of whether there was discriminatory animus motivating the decision to terminate DACA. Justice Sotomayor issued a separate concurrence saying that she would have allowed for further fact-finding on this question, given President Trump's previous statements regarding immigrants. The takeaway from this case is that, this is a second year in a row that Chief Justice Roberts has cast a deciding vote in a major case where he found that the federal government violated the APA. Last term, that the critical case involved the 2020 census, and this year it involved DACA. These cases can be read together to say that a close majority of the court will hold federal agencies accountable using the APA, where lower courts have repeatedly held that the administration overstepped its boundaries. I think that the APA just has proven a critically important tool for holding our federal agencies accountable in the last several years. That said, it's important that we get comprehensive immigration reform in place. There's still a need for a permanent solution. If the administration had not made mistakes in its repeal of DACA here, it would have likely survived court challenge. And if we're in a second term with President Trump, the administration will likely do just that, reenact DACA. And even if we have a different president, any administrative reform put in place will likely be limited in scope and effect and will be tested in the courts and potentially struck down, like DAPA was, a previous program put in place under President Obama. Congress can put in place comprehensive comprehensive reform that sweeps more broadly than any action that a president could take. So I do think that the court's ruling, while received favorably, also underscores the urgency for congressional action and finality, the need for finality. I'll note that there was one amicus brief cited by the court in this case, a brief submitted by Fortune 500 companies that argued that they would have had to spend upwards of $6 billion to replace DACA employees if the program had been struck down. So just observing that corporations have become a very important voice and partner in this space, and one that the Supreme Court turned to here. There has been no action from the administration on DACA since the court's ruling. However, this past Monday, Mark Meadows, White House Chief of Staff, suggested in an interview that the president is preparing an executive action on immigration issues and would be issuing something this week. To date, nothing has been issued, and there have been no further statements, but it's an area that we are following very closely. The court's ruling that the administration failed to give an adequate justification for terminating DACA as required under the APA does give the administration another opportunity to revisit DACA. So we're watching this space very closely. I'll move now to reproductive rights. June Medical versus Russo and Little Sisters of the Poor versus Pennsylvania. June Medical concerns a 2014 Louisiana admitting privileges law, Act 620, which required physicians who perform abortions to have active admitting privileges at a hospital located within 30 miles of an abortion clinic. If this law were enacted, it would have left just one abortion provider in place in the entire state of Louisiana. That clinic is located in Shreveport, Louisiana, about 320 miles away from New Orleans. Just 4 years ago, the Supreme Court struck down an identical admission privileges law in Whole Woman's Health versus Helsterded case that arose out of Texas and involved a 30-mile admission privileges law. Despite the unambiguous ruling issued by the Supreme Court, the Fifth Circuit ruled that the Louisiana law was constitutional, setting this question up for the court. We filed a brief on behalf of a number of civil rights organizations highlighting, excuse me, highlighting the fact that Black women in Louisiana are disproportionately harmed by laws that limit abortion access, and that the lack of access to abortion care has substantial ripple effects throughout people's lives. Here, the court issued a 5-4 decision by Justice Breyer, finding that Act 620 was unconstitutional. This case is probably best described as a non-loss than as a win. The critical fifth vote came from Justice Roberts, who made it clear in his concurrence that if it hadn't been for the 2016 Supreme Court decision, which he still believes was incorrect, that he may have come out differently, but here he was honoring precedent under the principle of stare decisis. In some respects, this is a case that keeps the status quo in place, but not a full-throated victory in any respect. The Little Sisters of the Poor case, Little Sisters of the Poor St. Peter's and Paul Home versus Pennsylvania cases were decided yesterday. This case is the Supreme Court's third involving the Affordable Care Act's contraceptive mandate, which requires that most employers provide health insurance to their employees and provide essentially no-cost coverage when it comes to contraceptive care. In 2017, the Trump administration issued a rule expanding the scope of the religious exemption under the ACA and the Religious Freedom Restoration Act. And they added a moral exemption that allowed non-religious employers to also be able to refuse to provide contraceptive care to their employees. Pennsylvania and New Jersey challenged the rule, and a district court issued a nationwide injunction stopping the rule from going into effect, which the Third Circuit affirmed. We joined an amicus brief along with a number of women's rights and reproductive justice organizations explaining the harms that the rule would cause to women of color, as the financial and non-financial barriers to contraceptive care would increase unintended pregnancies and aggravate medical conditions and threaten the economic security and well-being for many women who can become pregnant. In a blow to advocates, Justice Thomas authored a 7-2 decision holding that the administration had authority under the ACA to promulgate rules exempting employers with religious or moral objections from providing contraceptive care to their employees. Advocates are currently exploring next steps, which will likely include litigation in the lower courts. There's some estimates that this may have immediate impact on about 120,000 women in the country, according to data provided by the government. With respect to June medical and just state reproductive rights restrictions generally, we know that there is the Women's Health Protection Act, which would codify Roe and bar states from enacting laws that limit women's access to reproductive health care. That is a very important law that a number of groups support, that we hope will get some attention as we move forward. I want to close out by talking about the decisions issued just this morning with respect to President Trump and the question of subpoena power. Today, the Supreme Court issued decisions in Trump versus Vance and Trump versus Mazars. The first involved the question of Manhattan grand jury and whether or not they may gain access to President Trump's financial records. In Vance, the court reaffirmed that the president can't invoke absolute immunity, and also rejected the argument that the DA had to make a showing of a heightened need for the information. That case now goes back to the district court, where President Trump is free to advance other arguments, even if Vance ultimately gets the right to move forward with this third party subpoena in this case. This is being done in the context of a grand jury process that is secret and would not necessarily result in any public disclosure of the records. In the other case involving congressional powers, the court set forth kind of a four-factor test that courts must consider in determining whether or not a congressional subpoena is appropriate. I will leave to Tona whether or not you'd like me to elaborate on those factors further, but I would encourage you to look at pages 18 to 20 of the Mazar opinion. Those are probably the most important pages of the opinion that lay out the factors that courts should consider in determining whether or not a congressional subpoena issued to the executive branch is appropriate and would withstand scrutiny. So with that, I will pause there. You said of blockbuster cases by the court that touch on many issues. Happy to pause here and take any questions that you may have. And I also just want to recognize some of my colleagues who are with me, Erin Martin on our policy team, and John Greenbaum, who is our chief counsel at the Lawyers Committee for Civil Rights Under Law. So with that, happy to open the floor for questions.
Hi, everyone. I do want to flag that at the bottom of your screen, there is a Q&A section, so you can write in your questions there that you have for Kristen, so we'll give you a couple of minutes to do so.
And if I could chime in while folks are thinking of questions, Kristen, I wondered if you could comment, obviously we're in the midst of a sort of groundswell in terms of police reform. And I wondered if you could comment on the state of play with respect to any potential cases that you could see arising with respect to qualified immunity or any other issues that would address some of the sort of outcry and protests with respect to police reform.
Yeah, important question. I'm also going to ask John and Erin to weigh in on those points as well. I do see that there was a question I was just looking at involving Wisconsin. One of the participants observed that Wisconsin also required a witness to request an absentee ballot, a potentially life-threatening issue. That this is an issue that we're looking at in a number of places, just some of the unnecessary and particularly burdensome requirements that voters face in the wake of the pandemic. I do think that this is a season where we will continue to see changes and new developments because there are just a slew of cases that are playing out on the one hand to lift and address the burdens. And then on the other hand, there are a set of groups that are very much focused on restoring the restrictions or putting restrictions back in place. So you've got affirmative and kind of defensive litigation literally playing out on parallel tracks in many states. We will indeed share these slides on our website. Thank you for that question, Thomas. And I see that there is another question, given the rulings on Wisconsin and Alabama, what do we think is the best way forward to advance voting by mail and or absentee ballots? And I do think that on both the House and Senate side, we've seen some very important work put in place to address what we need to have successful absentee voting this season, and funding is really critical. There are states that are in dire straits because of the pandemic and the economic downturn, and that do need Congress to allocate real support, real financial support, so that they can put in place things like postage paid envelopes for voters, or automatically mail out, absentee ballot applications to voters. There are costs tied to these things. There's also a need for poll worker recruitment, which takes resources. So I do think the allocation of funding is critical and time sensitive, and that the U.S. Postal Service, again, is another important part of the equation. The USPS plays an outsized role this season. We need to make sure that they have proper funding, and we need oversight to really shine a light on how they are operating, how they're handling mail. Is it uniform across the country? Because questions about things like postmarks actually will prove critical to whether or not a ballot gets counted in some communities this season. John or Erin, do you want to weigh in on kind of what's playing out in the courts and whether or not we're likely to see some of the issues that have come up in the reform process surface in the courts this season?
Hi, so I haven't specifically looked into that. John unfortunately had to jump off to jump to another call, but I think that's something we'll definitely be monitoring during the upcoming term.
Great. I had one question come in over email. One of our participants was having trouble getting into the question format, so I can share it here if you don't mind. The question comes from Shelby Boxenbaum from Senator Menendez's office, and Shelby says, I was curious to get your thoughts, Kristen, on the thinking by some that Roberts is a new swing vote and that he will protect us from a court going too far to the right. What are your thoughts there? That question again is from Shelby Boxenbaum.
So he is most certainly an institutionalist. I do think that Roberts is somebody who cares deeply about the reputation of the court. And I was not surprised by the census outcome last season. I thought that the administration had done a terrible job in with a straight face, trying to suggest that the real reasons behind the 11th hour incorporation of the citizenship question were because they wanted to be able to more effectively enforce the Voting Rights Act. I mean, it's borderline laughable. And I just did not see Justice Roberts co-signing a decision that frankly would have been one premised on lies from the administration. And the way he handled it, I think, is kind of true to form. He kind of gave the administration a chance to go back to the drawing board and didn't say, I'm not definitively ruling out the possibility that you can move forward with this, but I'm sending you back to the drawing board. And in a way in which we knew that the clock had run, right? And in a way in which we knew that the census now would move forward without that question. And I think that that's kind of a pattern we're seeing with Roberts, where he'll buy time. He cares deeply about the reputation. I think lies won't fly with him outright. Lies will not fly with Justice Roberts. You got to pass the smell test. But I do think that he's not necessarily as progressive as his predecessor. You know, as the you know, kind of former swing vote of the court, Justice Kennedy. I do think that at the end of the day, though, he is unquestionably the most powerful person on the court. He is the vote that you know, I think advocates are working to secure, and the statistics kind of bear that out, with this term placing him in the majority 98% of the time. I mean, he is the vote that everybody is working hard to get.
I also want to, I think Esmeralda Simmons had her hand raised earlier. Do you have a question you'd like to ask?
It looks like her line may be muted.
Okay.
Muted.
Can you hear me now?
Yes.
Yes, we can hear you.
Okay. Thank you, sisters. This has been great. Of course, the cases just keep rolling in. This is not quite summer vacation anymore. But I would like thank you for handling the affidavit ballot, paper ballot, soon to be even more horrific situation in the fall, and what we need to anticipate regarding that. Do you think that I should ask a direct question. There aren't any cases that are in the pipe now that will affect the November election?
There are many cases that may impact voter access for the remainder of the primary season and for the general election in November.
I'm talking about voter access, exactly. I'm not talking about the results of the election.
No, there are a slew of cases that will impact the ability of voters to access the ballot in respective states, right? We don't have any federal and uniform standards. So what we see are case by case efforts to address the restrictions that will prove fatal for some voters given the unprecedented pandemic that we're up against. So by way of example, we have a number of cases, but I'll highlight one involving the state of Tennessee, where officials have taken the position that the pandemic is not a legitimate grounds by which you should get an absentee ballot. In addition, there is a law on the books in Tennessee that imposes criminal penalties on people who distribute absentee ballot applications to voters. So, you know, we are involved in litigation to address those issues, and you know, we continue to encounter a lot of hostility and resistance in some parts of the country. So I think that it's important to be attuned to what's happening in your state, because you know, these cases will have impact on access, but may also be appealed. And so, you know, it's an active area, Esmeralda, a very active area.
Very. Thank you very much.
Thank you. We have another question. Do you think it's likely that the sex discrimination definition in the Title VII case can or will be used for other federal anti-sex discrimination statutes like Title IX, for example? or will courts try to limit the Bostock holding to just Title VII?
So Justice Alito issued this very lengthy dissent in that case where, he kind of ran through a litany of statutes that he felt were potentially upended by this ruling. And I do think that there will be efforts statute by statute to extend or ensure that LGBTQ people enjoy the discrimination, enjoy protection from discrimination based on sex that the Supreme Court has now made clear is unlawful. And so one way to think about how we deal with this is the Equality Act, is some wholesale effort at the federal law to look at this issue very broadly and generally across the board. And we'll see if that happens. But I think that there are many chapters yet to be written in this story, and the court's ruling here won't be the final word. There's still a number of other contexts where this question is a live question that will need to be resolved.
Mm-hmm.
I'm not sure if there are any other questions. If not, I will make reference to take the liberty to highlight a set of cases that I believe are in the court pipeline and that are important, I think, for us to keep our eye on. There's a case currently before the First Circuit that involves the question of race-conscious admissions efforts in the higher ed context. And the First Circuit case actually involves Harvard University and their affirmative action effort. The federal district court issued a ruling finding that Harvard University's race-conscious admissions efforts are fully compliant with Supreme Court precedent. And the litigants in that case have appealed to the First Circuit. The litigants in this case, who are financed by Ed Bloom, a name that may be familiar to some, have also mounted similar cases at the University of North Carolina, a case that goes to trial this fall, and a case in state court involving the University of Texas at Austin. So just wanted to flag those three important cases. They're cases in which the administration, in which the Trump administration has weighed in, arguing that these efforts are unlawful and unconstitutional. And I think are just an incredibly important set of cases to keep your eye on if you're somebody who cares about diversity in our country and cares about diversity on our nation's college campuses in particular. No doubt the goal is to use these cases as an opportunity for the Supreme Court to revisit its prior precedents in this area. So Tona, it looks like we may be out of questions. The one thing that I did not get a chance to do, but had hoped to do, was just to recognize how active the Senate has been in the Supreme Court this term. I know that Senator Booker and a number of other senators have been active in the Comcast case, in the DACA case, in June Medical, in Bostock, in Little Sisters of the Poor. Great to have this time to spend with you and with Senate staff to talk about these incredibly consequential cases. And thanks for the work that you all do to ensure that your voices are also presented to the court for consideration as well.
Thank you so much, Kristen. Thank you so much to your team, Aaron and Isabel, who helped put this together. And thank you to Dan Schucker on Senator Booker's team for helping to organize this. I think this was a really important conversation to have as the Supreme Court wraps its term and we look to what may be coming down the pike. So I hope that we'll continue to have ongoing conversations, and just thank you so much for all the work that you all do.
Excellent. Thank you for having us. Take care.
Thank you. Take care.